on cause number DC 211797, Ricci Plaza, Dallas versus Freedom Equity Group, LLC. Council, make your appearances.
J.D. Blakely of Dunn Sheehan on behalf of plaintiffs.
Darian Howard on behalf of the Davis Law Group.
Frank Chandler here on behalf of Garrett Salinas and Salinas Partners.
All right, let's go ahead and proceed.
Your Honor, this is a plaintiff's motion for default judgment on liability only against non-answering defendant, Davis Law Group. What happened in this case, we filed our petition on February 4th with multiple defendants. Attempted service on Davis Law Group were unsuccessful. I think as a result of those attempts, Corin Davis, who is the registered agent and owner of Davis Law Group, called me on March 19th and agreed to waive formal service of citation. And I agreed to a 30-day answer deadline. If you'll see at Exhibit 1A, which is attached to my affidavit, is the email where I sent him, saying, Mr. Davis attached as a Rule 119 waiver of service, stating that you accept service of the petition and waive any formal personal service. I tracked the language of 119. And on March 23rd, Exhibit 1B is where Mr. Davis signed and had notarized that Rule 119 affidavit of service sent back to me. I filed that on March 24th, so it's been on file for close to 2 months now. Under the rules, his answer date would have been, Davis Law Group's answer date would have been April 19th, because under Rule 119, a service that way becomes effective as of the date of the affidavit. However, like I said, I agreed to give him a little extra time. So under the agreement, his answer deadline was that Friday, April 23rd. Nevertheless, Davis Law didn't file any kind of answer, didn't file any kind of appearance in this matter, hasn't as of us sitting here today. So we filed for a motion for, we filed for default on liability only at this point on April 26th. And that's why we're here today asking for default judgment. We also on April 26th filed the certificate of last known address per Rule 239A, and have also submitted a proposed default judgment on liability against defendant, Your Honor.
All right, anything else by any other party?
From the defendant, Your Honor, an answer was filed by Davis Law Group on May the 10th, before the actual hearing date was set, I believe.
Okay, well, if there's an answer filed, then I can't grant default judgment, right?
Sorry, Your Honor, I haven't received a copy of that answer, and I'm going to look on the docket real quick.
I see it. It looks like it was filed on May 10th.
Okay. I guess I just didn't receive service of it, but if it's on file, it's on file.
And if I didn't, I thought I sent it, that may be my mistake.
Okay.
On my part, yes.
Yeah, I would have pulled this hearing. I'm sorry about that, Judge. I didn't see the answer.
It's okay. All righty, guys. Well, that'll be it for today. And then is this case set for trial yet?
Yes, Your Honor. I think about a year out, maybe a little less. Like I said, there's multiple defendants, and at this point, everyone has either answered or defaulted on liability. So I think plaintiff's next step will probably to schedule in the near term some kind of hearing on damages for the defaulting defendants. And we'll get going on working with answering defendants to see if there's a way to resolve these matters. And if not, we'll proceed with normal discovery and all that good stuff.
Okay, sounds good. You guys be safe, okay? And we'll go from there.
Thank you, Judge.
You guys be safe.